morning, Ms. Pumpkin.
Good morning. May it please the Court. I'll start with the motion to suppress. The defendant was arrested in North Carolina by federal marshals pursuant to a Massachusetts arrest warrant. He was held by the federal officers in the U.S. Marshal's office in Raleigh for about 6 hours before the Massachusetts troopers arrived in North Carolina. When they arrived, the troopers read the defendant his Miranda rights, but the form did not, they were using a federal form, which they scratched out at the top and put in Massachusetts, and the form did not include the statutory right to make a telephone call. The troopers took a statement from the defendant over the period of 2 hours, during which time they never offered him the right to make a telephone call. In fact, he was not advised of his right to make a telephone call until after he arrived back in Massachusetts.
Ms. Pumphrey, is it you say Scoggins, if I have that correctly, doesn't apply here because North Carolina had its own statute? Is that why?
I'm not willing to concede that Massachusetts law does not apply. That's what the motion judge found. But
she found it did apply, correct? Or didn't?
Did not apply.
Okay.
The Massachusetts statute.
But in it is Scoggins.
It
right?
is Scoggins.
Which was South Carolina.
Yeah,
not North
South Carolina.
Yeah, Scoggins.
South
right.
Carolina.
But quite apart from what law, I mean, it seems to me implicit in that case was that Massachusetts law did not apply.
Okay. But I would suggest if Massachusetts law doesn't apply, then North Carolina law.
I mean, you know, the requirement doesn't apply. That's what I'm saying.
Well, I would suggest
the requirement doesn't apply.
That because the defendant was held in federal custody, and there is no federal law on this issue, the Supreme Court has said in that case that the law of North Carolina should apply, and North Carolina does have this law. North Carolina differs a little bit from this, but I would suggest if Massachusetts doesn't apply, then North Carolina does.
Okay. All right. My second question is, it's not an easy conflict of laws resolution, okay, but isn't there a reasonable argument that the Commonwealth makes that whichever way you go, there was not a violation in that you couldn't show, I think, and maybe there's a finding that there was no intentional deprivation, even if you say somehow that there was a duty under Massachusetts law, and with respect to the North Carolina law, I guess my question is it the case under North Carolina law that if, as the Commonwealth suggests, that if a defendant is provided with Miranda warnings and signs and then talks to the police, that the purpose of the telephone call and communication, the fact that a warning wasn't given is not going to mean suppression of what occurs after the Miranda warnings have been given?
Under North Carolina law, there's even a case, and it's cited in my brief, and I don't have it at the top of my head, pardon me?
Hill, North Carolina versus Hill?
I'm not sure. But that the evidence wasn't just suppressed, but the case was dismissed. I mean, North Carolina law is really as strict as Massachusetts law. Must, without unnecessary delay, advise the person arrested of his right to communicate with counsel and must allow him a reasonable time and reasonable opportunity to do so.
But if that's Hill, the facts were quite different. The police denied the defendant the right to communicate with his attorney, and the attorney had come to the jail after the defendant was arrested for operating under the influence, and it was very important whether the attorney would be able to see at that particular point whether the defendant was under the influence. It isn't really a phone call.
Okay. Well, this really is really only the denial of a phone call, because he was definitely Mirandized, and he definitely made very detailed statements, very detailed and long confession. I would suggest that because he was held in federal custody and he was interrogated then by Massachusetts troopers, the North Carolina, if the Massachusetts statute does not apply, then the North Carolina statute does apply. And even the Commonwealth says in its brief that the defendant was not in Massachusetts State Police custody until the next morning, when he was taken after he had given his statement and he appeared in North Carolina court and waived extradition. The Commonwealth also suggests in the brief that there was a telephone in the interview room, so the onus is on the defendant to ask to use it, but that's not the state of the law under either of these statutes. And I'll go back just quickly to the Massachusetts statute, which basically, if you parse the words of the Massachusetts statute, the motion judge found that it did not apply. But it says, the police official in charge of the station or other place of detention having a telephone shall permit the use of the telephone. And then if you go to the end, it says, any such person, such arrestee, shall be informed forthwith upon his arrival at the station of his right to use the telephone. So I think if you parse the exact words, it's not so very clear that that statute does not apply, especially if you just concentrate on the last sentence. Any arrestee shall be informed forthwith upon his arrival at the station. So the statute envisions other place of detention and doesn't necessarily talk about the police official in charge of that station.
But what about Scoggins in that regard?
Scoggins in that regard said that this statute did not apply. The prejudice was enormous because even the motion judge recognized the prejudice was enormous because the motion judge says the importance of the right to make a telephone call. In this case, the right is especially sensitive because Haith was far from home and arguably no one knew where he was. Had he spoken to a family member, had he spoken to an attorney, he would have been informed clearly of his right to silence.
But that's what the Miranda warning did too.
That's true. I would suggest that this is like Mr. Joya's before me defendant. This is not this is an unsophisticated defendant, and he was far from home, and
it's more that the family member not just would have said, you know, you have the right to remain silent. Don't talk.
Don't talk. Exactly. And he had been held at this point for at least 8 hours, 6 hours before the troopers arrived, and then 2 more hours. So he had been held for a long time, and he was far away from home and very much afraid. Assuming that Massachusetts statute does apply, the purposeful deprivation prong that Judge Botsford referred to, I would suggest that 8 hours of being held without being informed to use the right without being informed of the right to use the telephone has to be interpreted as purposeful. The troopers knew that there was the troopers knew this. I mean, they've interrogated thousands and thousands of defendants. I can't help but think that this has to be a purposeful deprivation. There is a.
The troopers weren't with him for 8 hours.
The troopers were with him for 2 hours. There's a Superior Court case on point, and it's Everett. And there, with really no more evidence than this, the Plymouth Superior Court found a purposeful deprivation just because the troopers know that they have to offer the telephone. And then the Commonwealth argues in its brief that evidence from Dedrick Cole and also from the defendant's aunt was cumulative of the confession, and so there's no prejudice by allowing the confession to come into evidence. But here I would suggest that both of those testimonies were fruit of the poisonous tree, especially the Dedrick Cole testimony, because the troopers learned of Dedrick Cole through the confession, and so they went to Dedrick Cole, and that would not have been discovered had the confession not been made. With respect to the aunt, the record's a little less clear, but from what we can see from the record, I would suggest that that's also fruit of the poisonous tree. I would also point out to the court that the suppression judge expressly found that the troopers never offered the defendant the use of a telephone, nor did the defendant ask to use the telephone. When you get to the same issue in the trial transcript, the troopers, this particular trooper's testimony is much more explicit than it was at the suppression hearing. At the suppression hearing, it was evasive. But at the trial, his testimony became much stronger. I asked if he wanted to use a telephone to call his aunt. Other than the confession, the testimony of the defendant's conversations with Dedrick Cole and his aunt, there was really very little evidence of guilt. Both of these witnesses were products of the North Carolina confession, so their testimony would have been suppressed also. The manslaughter instruction. The entire theory of the defense in this case was that Zena Williams was the person with the motive to kill Andrade, and that she lied and manipulated Mr. Haith into helping her by convincing him that his children would be in danger if he did not help. So the entire theory of the defense was that the defendant was guilty of manslaughter and not of murder. The defense requested the instruction on imperfect defense of another, based on evidence that this very manipulative Williams convinced Mr. Haith that his children would be in physical danger if Andre were allowed to live. The issue is fully preserved because the instruction was requested and the instructions were objected to after they were given.
And excuse me, I should have asked you this before, but the Commonwealth, I believe, argues in its brief that North Carolina has ruled that a defendant is not prejudiced by the failure of the police to advise him of his right to communicate with friends under the North Carolina statute, where the defendant was told of his Miranda rights, waived those rights, and then voluntarily gave the statement to the police. And that's what happened here. So that if we were to apply North Carolina law would actually would not suppress anything in this situation.
Well, in my brief, I pointed out to a case in North Carolina where not only was the confession not suppressed, but the case was actually dismissed as a violation of the statute. I don't have the case right in front of me. I'll supplement with a 16L letter. The manslaughter instruction. There was ample testimony on this issue, and the evidence is liberally viewed in light of the defendant. Quote, all reasonable inferences should be resolved in favor of the defendant, no matter how incredible, and that testimony must be treated as true. Here it came in through two witnesses. First was Dedrick Cole, who testified that Andre was going to testify against members of the Zeno Williams family, and if he did so, that Mr. Haith's children would be in danger. Cole also testified that Mr. Haith believed this threat. Trooper Moran testified that Mr. Haith believed that Zeno Williams' family would be in danger, and he also testified that Mr. Haith's children, Mr. Haith believed that his children would be in danger if he didn't do this.
Humphrey, to give a manslaughter instruction here on this theory, it would have to be that if one believes, and maybe legitimately so, that if some event happens in the future, my children will be in danger, that means you can go out and confront and attack the person?
That was the argument at trial. It was tried under a manslaughter. The defense at trial was manslaughter. It should have been manslaughter. Manslaughter instruction should have been given because he was so under the influence of Miss Williams that she manipulated him, coerced him.
Okay, but that's not really about defense of another, is it?
Well, that was the trial theory, that it was an imperfect defense of another.
But the defense is of the children, correct? That's
Right,
what the theory was?
right. Right.
What were they in imminent danger of suffering?
Throughout the entire transcript, what it really refers to is just they were in danger, they were in danger, they were in danger. It never really specifies. These are not nice people. They're drug dealers, and Mr. Haith believed that they were going to be killed. But the actual words imminent danger were not used in the transcript, but the word danger was repeatedly used, and it was ample testimony that he believed it. I would refer the court to the Martin case, which is in my brief. There, the court recognized the defense of others and held that the actors justify in using reasonable defense where a reasonable person would believe that it was necessary for the protection of a third person, and in the circumstances as that reasonable person would believe them to be, the third person would be justified in using such force to protect himself. The 33E argument. Again, this case was tried under a manslaughter theory, even though manslaughter was not instructed. A verdict of second degree or manslaughter would be more consonant with justice. There was ample evidence that Jamal Haith was just a pawn in this scheme to kill this man. According to his aunt, at the very beginning, Zeno Williams even created this subterfuge to even initiate the plot by persuading him to come meet her by telling him that the children were sick.
Was Ms. Williams prosecuted?
I don't know that. I'm sure that the assistant district attorney will know that. According to the taxi cab driver, after the killing, Zena Williams did all of the talking. She paid for the fare, and she seemed to be very much in charge. According to Dedrick Cole, Mr. Haith believed he was going to that Andre was testifying against these family members, and that his children would be in danger. And finally, again, Trooper Moran's testimony of exactly the same thing. There was also testimony that, also evidence that Mr. Haith eventually feared that Williams was going to have him killed also. And he got off the bus, he kind of panicked and got off the bus early and left her because he was afraid that he was being completely set up as well. Anyway, there was extreme emotional pressure on Mr. Haith, justifying a reduction of the murder to second degree or manslaughter. And for the fourth argument, I will rest on my brief, unless there are any other questions.
Thank you, Ms. Pumphrey.
Thank you.
Good morning, Ms. Alford.
Good morning. Good morning, Your Honors. Pamela Alford for the Commonwealth. To address Justice Botsford's question first, Zena Williams was convicted of first-degree murder in this case. That has been briefed, and it will be before this court.
It wasn't a joint trial, though, was it?
No, two separate trials. Haith was tried first.
Now, clearly, North Carolina law has got to apply to this telephone business, doesn't it?
No, Your Honor, I would disagree. He was arrested and held by federal marshals. And if you look at the cases that my sister cites, United States versus DeRee, that talks about when a warrantless arrest. How do you determine whether somebody's arrest was valid or not? And DeRee does talk about that you look that if there's no congressional authorization, you look towards state law. The Commonwealth would suggest that DeRee has, in subsequent decisions, been limited. Also that there has been a subsequent congressional authorization, and also that it doesn't apply here. We're not talking about the defendant's arrest. We're talking about the defendant's custody. We're talking about the defendant's statement, and under what circumstances the statement may or may not be allowed into evidence. So there is nothing in federal law that the Commonwealth has seen suggesting that he has a right to a phone call.
Oh, okay. So you're saying he was arrested by federal authorities and there is no federal requirement to do this?
He was in federal custody.
But in a state jail, right? I mean, it wasn't a federal facility that it was in, correct?
That is.
He was arrested by federal officers and held in a state facility under an agreement that the federal government has with the states.
No, that's partially incorrect. I believe the record reflects he was taken by marshals, that when the Massachusetts troopers went down to take the statement, he was in marshals' custody at marshals' headquarters. After they took the statement, the defendant was transported to the Wake County Detention Center where he spent the night. That is state custody. The next morning, the defendant makes an appearance. The custody is transferred to the Massachusetts troopers. There is also a Stoughton Department police officer who has appeared. He is transported to Massachusetts where he's taken to the Stoughton Police Department for booking.
So the actual statement was given in a federal headquarters or something?
Correct.
So I guess what I'm driving at is the right to make the telephone call applies when you're arrested, does it not? Or booked? In Massachusetts.
The Massachusetts applies that when you are booked, in cases have said that it has to be upon arrest.
But
Yes.
it's the officer in charge of the facility that has to make sure that happens, right?
Correct. And if you look at Commonwealth versus Scoggins, it talks about that and that was a case where there were I believe it was state troopers, if not with Massachusetts police officers, that they weren't in control of the South Carolina facility. And the same thing occurred here. The Massachusetts troopers were not in charge of the federal facility.
Well, I guess that's what I'm saying to you. If he's arrested by federal marshals, and is he booked by them too?
It is unclear whether he is. It is not clear whether he is booked or not. The record doesn't reflect.
Well, all right. Let's go through it a little bit analytically. If he's arrested by federal marshals and booked by them, there's no requirement of any telephone call, right? Under federal law.
Yes.
All right. Now, if he's brought down to the North Carolina jail, you've got cases, which I haven't read, that say in these circumstances, any violation of any such right is not prejudicial.
That it would be a technical
So
violation.
now we're down to, what? Technical, right. So now we're down to Massachusetts, and how could that apply to Massachusetts when the troopers aren't even there?
Well, is
Can I
the
just
answer
ask
to
you-
that? Oh,
Can I just follow up? The judge found, and I don't know, I mean, I don't think anybody's challenged the finding. The judge found that in February 2002, the defendant was arrested, the judge's word, in North Carolina by federal marshals.
Correct.
So doesn't that answer Justice Glaney's question?
No, it doesn't say who booked him.
Well, he was arrested.
He was arrested by federal marshals there was a, Massachusetts had put in a warrant.
The fugitive warrant, right?
The warrant for
It
Massachusetts
just says arrest warrant here.
and I'm not sure how much is clear from the record. And that's another point, that at the motion to suppress, the presiding judge did a very careful inquiry, both before and after, over what exactly was at issue. And defense counsel, the Commonwealth would posit, agreed that what was at issue was the conduct of the Massachusetts troopers. And I would say that this is a Commonwealth versus Silver case, that now that after the record was developed, the judge made her findings on Massachusetts law. There was no motion for reconsideration. That the defendant is seeking to raise issues that weren't raised at the evidentiary hearing. And under Commonwealth versus Silver, the Commonwealth doesn't have the burden to flesh out issues on a motion to suppress that the defendant hasn't raised. So to the extent that the defendant is trying to look at what other people did, the Commonwealth would suggest that they've waived that issue through their representations to the judge at the motion to suppress.
I have a question. I understand the reasoning that Justice Graney just went through, but the police from Massachusetts, the troopers from Massachusetts were there and could take the statement only because they're authorized by Massachusetts law to be troopers, to go down and do what they did. They're all governed by our law, otherwise they couldn't even be there and they couldn't get the statement. So then why shouldn't they, just logically, be governed by our law?
Because 33A by its terms talks about places of detention. I suppose as legislature could state that make a trooper governed to, that a statement is only admissible before certain things happen.
So
But
you're saying it by its terms it isn't applicable here because the Massachusetts police weren't there at the time of booking and the time when all this occurred?
no,
the
because
facility wasn't a Massachusetts.
Massachusetts,
facility.
all right,
Correct.
okay, all right.
it was
That's what Scott is.
So if somebody is arrested in Massachusetts, somebody from another state is arrested in Massachusetts, and the state from which the person came from has no requirement of a telephone call, but Massachusetts does, Massachusetts is obligated to give him the telephone warning because he's being interrogated in a Massachusetts facility.
He's being held in
Yes.
custody. Not
I would
because
say
he's
that
been-
is correct.
It's because he's been held in custody.
Correct. In a
In
place
other words,
that
I have no idea. Let's assume you flip it. I have no idea if it's a North Carolina person, and if he makes absolutely no statements in Massachusetts, I assume, if North Carolina wanted to look to Massachusetts, that they could say, well, he was held in custody and he wasn't told. You know.
I suppose that they could. If there are no statements, there'd be nothing to suppress.
So, Ms. Alford, you're saying, if I follow your argument, that if our law said a person has to be given a right to a telephone call before he can make a statement, just theoretically, that's what the statute says, or our case law or something, then you would say that the Massachusetts State Police would be governed by that?
Yes, I would say that would be a different case. We're talking about a statutory right here,
Okay,
not
I
a
understand.
constitutional right.
But let's assume for the minute that North Carolina law applies, and I know that's not where you are, but assume, am I right that you cite a case that says in a situation like this, where Miranda warnings have been given, and then statements are made, and let's just assume, there's no issue about voluntariness or the validity of the Miranda warnings, that any problem with the telephone statute sort of disappears?
That is correct. I cite two cases, State versus Kerman and State versus Chapman. I believe one cites the other. And that's exactly what they hold, that in North Carolina, the violation cannot be technical. It has to be material and prejudicial. And those cases hold that where there is a Miranda, where it's been voluntarily waived, the right to communicate, it doesn't prejudice, the failure to inform a defendant of the right to communicate doesn't prejudice him. And here, the Commonwealth included in its supplemental appendix the Miranda What Rights form. And I think it was a detailed form. It gave, the defendant signed that form twice, once to indicate that he understood his rights, and once to waive his right to speak to a lawyer, that any violation under North Carolina law would be merely a technical violation. State versus Hill is a very different case. That was a case where not only was there an actual denial of the right, but it also had to do with evidence that was no longer there. That the counsel had the right to see his client, to see the state of intoxication. Once the time had passed that the defendant got out, you couldn't get that back. That case is worlds away from what we're talking about here. And
once we get the telephone business out of the way, you've got a pretty substantial case of guilt, do you not?
Yes. Even if this case, the evidence here was overwhelming against the defendant, and the defense never argued below, never moved to suppress Dedrick Cole's statement on the grounds that it was fruits of the poisonous tree, and I would suggest that that issue is waived. I do not believe that it's clear that it was fruits of the poisonous tree. It was not raised below, and even as my sister said, that at trial, Trooper Moran noted that he had talked, or I believe the record reflected Trooper Moran had said that he had spoken to the aunt, and that may have been at the motion to suppress. And so I don't think the record would support that the statement to the aunt, where he said, I wasn't alone, was fruits of a poisonous tree. The statement to Dedrick Cole is substantially similar to the statement of the police. And there was a host of other evidence supporting that, that the defendant had no money before he went, that he had money when he came back, that he had a broken fingernail, that the defendant's statements were corroborated by the physical evidence, the finding of a screwdriver, that that other witnesses at the scene identified Zena Williams, and while not identifying the defendant, saw that she was with somebody matching the defendant's description. If I could speak to a moment about whether the Commonwealth contends that there was no error here. Even if there was an error, it was not intentional. Contrary to, I think, what was represented, it is the defendant's burden to show that there is an intentional violation of the telephone rights statute. And the Commonwealth would suggest that Commonwealth versus Parker applies here. In that case, they had been given Miranda, I believe, that there was a phone. And here, the evidence is clear that the troopers came in, there was a phone in the room, the defendant never requested to make a phone call, and more importantly, there's evidence at the motion to suppress that whatever the defendant asked for, he got. That when he said he was hungry, they got him some food. When he asked for a cigarette, that they took a smoke break. There's simply no evidence, even if there was some violation of the statute, that it was intentional as to merit or warrant suppression under the Massachusetts statute. Commonwealth versus Everett is not on point here. There was arrest. It was taken into the Massachusetts station, but he wasn't booked. So Commonwealth versus Everett just simply does not apply. moving on to the manslaughter instruction that the defense requested, the defendant was not entitled to a manslaughter instruction categorically or on the elements of the traditional defense of others.
Well, you can't get a manslaughter instruction if the theory of the defense was at some future date, as I understand it, the victim might harm Williams's children. Wasn't that the theory?
It was. You can't get...
Certainly it doesn't justify going out and murdering somebody.
Absolutely not. There was no imminent harm here. And even before you get to that, I think it's important to note that the defense of others was predicated through Martin and Commonwealth versus Martin and Commonwealth versus Monaco that there was some type of unlawful conduct. Martin was a case of an allegation that a prison guard was beating an inmate. Monaco was a case where they alleged that a police officer had shoved the defendant's girlfriend. In Monaco, they found there was no imminent fear. Here, the victim is being described as doing nothing more than testifying against the Zena Williams family.
Was there any evidence here that the defendant believed that the victim would personally inflict harm, serious harm, upon the children?
No. The only evidence was that the victim was going to testify. And not only is there no imminent danger of serious bodily injury here on a traditional analysis, but to the extent that the defendant says we shouldn't look at this in the traditional sense, we absolutely should. And if we don't look at it in the traditional sense, there's no unlawful conduct here. I think the Commonwealth would suggest that you can decide this case without ever looking at the elements. This is a similar case to civil disobedience cases, such as Commonwealth versus Hood, where they said, well, this isn't the type of case that a defense of others applies to. Where there's no unlawful conduct, the defendant simply isn't entitled to a manslaughter instruction. And here, there is no imminent harm of serious bodily injury. Certainly, there were no steps to take to avoid physical combat. The defendant plotted out a murder and then methodically carried it out. So there simply was no basis for a manslaughter instruction. And for that reason, 33E review is simply not warranted here. This court, I think, has eloquently said in Commonwealth versus Weichel, which was a motion for new trial case, where the defendant claimed he did not bring up evidence due to a coercive situation, that a hard choice is not the same as no choice, that the defendant shouldn't be given the benefit of making a bad choice with the resulting impairment of the integrity of the jury verdict, and that's simply the situation here. If there are no further questions, I will rest on my brief.
Thank you, Ms. Alford.
Thank you.